Hello, NAIFA Delaware. Dan Reisinger here, your president. You're not going to believe this, but we are having our meeting at the Christiana Hilton in part of this snowstorm. We've got 4 of us here at the meeting, so we're going to video this and allow you to listen to the presentation from Steve Klein, who has joined us from NAIFA National about the ACA. Couple quick announcements, and we'll probably be taking some breaks during this. But you'll need to watch the video in entirety and then certify to us that you did that, and then that's how you will earn the CE. So I will skip the Pledge of Allegiance like we normally do, and survey. The survey's out. We're getting some really good responses on the survey. There's a link on the Monday morning emails. Please take that survey. If we don't get your survey, we're going to be making phone calls because we're trying to get as close to 100%. I think the 63 that we have back in, we're getting some great information that's going to help our incoming president plan for next year. The new NAIFA Delaware Awards have been announced. They are on the website, right, Kate? They are on the website. Kate's right behind the camera. She's off camera. I think they're on the website starting this year. There'll be the President's Citation for Association Leadership. There will be the Benetti Lifetime Association Achievement Award and the Carl Hill Award. So if you need some more information on that, check the website. If you have any questions about qualifications, just let me know. March 19th, we are having the Advisor 2020 workshop at the Blue Ball Barn in Wilmington. We need some reservations to come in. Please try to get that information into us as soon as possible.
Dan, it's
Yes,
Dennis. How do
it's
we
Dennis.
get the book? To read the book prior to the event?
So that's a great question, Dennis. When you register for the event, which you can now do on a link on the website and then pay with a credit card, National will be mailing the book to you it's going to be starting to come out next week. I read the book. You can easily read the book in a week's time, just in the evening, taking an hour. It's a great read. Really good comments coming back nationally from the workshops that they have run. So please support us in our national programs and attend Advisor 2020. April 22nd is our legislative meeting in Dover, Delaware. That will only be held in Dover, Delaware. May 5th and 6th is our career conference. Please get your tickets as soon as you can. All the links are on our website. A few promotions for the national website. If you have not been at NAIFA.org, and our surveys are showing that I think 90% of our respondents have never been on the national website. Folks, you're missing a lot of resources. There's 2 that I want to talk right now about. One, the virtual library. The virtual library is available to members as part of your membership. It has a ton of information that you can go on and easily create a little information proposal for your clients on virtually 1,000 different topics: IRAs, health insurance, disability. Great information that's available to you at your fingertips. It's called the Virtual Library. Steve, it's under Practice Resources. Practice Resources, main tab from the NAIFA.org website. Please check that out. Copy Talk. I don't use Copy Talk. I've heard a lot about it. It's where that you can record notes from your clients and it converts it into actual text, so you can keep that client information for compliance reasons. It's called Copy Talk. Please check that out. Our 3 sponsors today: Mike Walker from Mid-Atlantic Benefits Group, also Health Insurance Associates, Nick Moriello, and the Weiner Benefit Group. We really appreciate their support in helping us defray the costs of this. They are great advocates of NAIFA Delaware and NAIFA, and please remember to thank them when you see them. So let's turn it over to Steve Klein. Steve, your actual title at NAIFA is?
Actual title is Director of State Government Relations.
State Government Relations. So Steve's going to be here, and he's going to talk a little bit about the ACA. So without further ado, Steve, take it away.
Great, will do. All right, Dan, thank you very much. And again, my name's Steve Klein, and I'm you're part of the NAIFA national team, and I'm one of the NAIFA state lobbyists, or I should probably say one of your lobbyists actually. And I've been part of the NAIFA team for over a year, and a large part of my job this year has really been covering health insurance issues for NAIFA, and that's what I'm going to talk to you about this afternoon. And as Dan and Kate and Debbie had asked me to do, I'm going to focus on the Affordable Care Act and I think what agents and brokers should know for 2015 and beyond. Most importantly, if you get the next slide, please. Most importantly, I'm talking about some important provisions of the Affordable Care Act that will be taking effect this year and beyond. That will be of importance to both you and of course, your clients as well. I'll also tell you what Congress is doing. In fact, there's already a number of proposed bills to amend the Affordable Care Act, and of course, I'm going to get into a lot of those a bit later on. I'll also tell you what NAIFA is doing. In fact, I'll tell you about NAIFA's advocacy on Capitol Hill and state insurance departments all throughout the country. And as we get toward the end, I'll tell you what the Supreme Court might do. I think, as everyone is keenly aware, there's a very major case before the Supreme Court right now that challenges a major part of the Affordable Care Act, and that could dramatically reshape the health insurance market once again. So I'll definitely get into that a bit as well. I'll end by telling you, I think, what else agents and brokers should know for 2015 and beyond, and then I'll leave room for some questions for these folks here, for what few folks we have here in the room, if they have any, and be happy to answer those. But you don't have to wait all the way to the end, that's for sure. So just hit the next slide, please. So let's start with the immediate, and that's the Affordable Care Act itself, and especially what provisions are going to be effective from 2015 to 2018. Much like in 2010 through 2014, more provisions are going to become effective that will affect not only your business but the business of your clients, and your clients in both the group and individual markets. And most notably, that'll be, of course, the employer mandate, which is probably the biggest one I'll talk about. There's new individual mandate penalties and forms and fees. I'll talk about that. Out-of-pocket cost limits have changed a bit, and I'll get into some of the shop exchanges and, of course, some of the new provisions coming into effect in the tax front, most notably the Cadillac tax, which is going to be coming down the road here in just a few years. Next slide. But let's start with the employer mandate, and this is probably the biggest piece of the ACA taking effect this year. And this is, of course, an issue for your clients in the group market. And as of January 1st this year, companies that have 100 or more employees have to offer an ACA compliant plan to at least 70% of their full-time employees, or face a tax penalty. And that tax penalty can be as little as $2,000 up to $3,000 per worker. Now, companies that have 50 to 99 employees have until 2016 to comply with this. And of course, I think, as everyone's aware, companies that have fewer than 50 employees are exempt. I should emphasize that this piece of the law now applies to full-time equivalent employees, and the IRS has come up with a way that you can determine what a full-time equivalent employee is. And companies essentially have to add two figures. One figure is, of course, the number of workers you have that are working at least 30 hours a week. As everyone knows, I think by now the Affordable Care Act changed the definition of full-time work from 40 hours back to 30 hours. So apparently, according to the IRS, you take that figure and then add that to the total of part-time hours worked in a month divided by 120. Putting those figures together, that figure determines whether or not one of your group clients is going to have to comply with the employer mandate in the Affordable Care Act. Now, of course, to comply with this, many companies will need to either look for a new plan altogether, or alter the current plan they have, or pay some of the fines that I just mentioned. And I should say this mandate has already had quite an effect on the group market. In fact, there was a survey from an employee benefits a firm called Benefitter, and they surveyed about 1,000 agents and brokers and found that 70% of the agents that they surveyed reported that their group clients have been getting hit with double-digit rate increases, and some as high as up to 60%. So this has already had quite an effect on the market. To the next slide, please. Now, for your clients in the individual market, there are some developments that are going to affect them as well. For your clients that have enrolled through one of the health assurance exchanges, they should have already received from the IRS a 1095-A form. And this form is a new form this year. It's kind of like you can almost characterize it maybe as like a W-2 for your health insurance. It shows that you bought health insurance, how much coverage that you received, and the information that you now need to fill out on your taxes to show that you're covered. I should emphasize that not all these 1095-A forms are correct. In fact, the IRS sent out about 800,000 incorrect forms. So, but now they have taken some steps to address this. They've said that if you filed your taxes with the incorrect information, you don't have to refile unless you think that you can be eligible for a refund. But this is still an issue that they're working to address. Your clients in the individual market should also know that there's another form called 8962, and this can help you calculate the subsidy that you would receive based on your 2014 income. Now, let me emphasize these forms will be especially handy because the IRS is going to be looking to see just who got too much of a refund, and they're actually going to be looking to claw back some of that money. In fact, the IRS may be looking to claw back as much as $4 billion in overpayments. And this comports with an article that appeared in the LA Times earlier this year, and the Times had estimated that between 40 and 50% of the households that received an Affordable Care Act tax credit are actually going to have to pay back some of that tax credit because, again, their income was higher in 2014 than what they estimated when they filed for the ACA tax credit. In some cases, they could end up owing so much back that they don't get a refund at all, that they actually end up owing money. So this is going to be quite an issue to watch. Next slide, please. And in fact, that also I should also mention that there was a survey from H&R Block, and H&R Block determined that they're expecting that as many as 3.4 million people are going to actually have to pay back some of the Affordable Care Act tax credit subsidy that they received. The IRS too is anticipating that many people are going to pay it back because they've actually instituted a new rule that says if you end up owing money back to the IRS because you owe money back from some of that tax credit, that money isn't entirely due on April 15th. The IRS has said you can pay that back in installments, but of course if you do that, late penalties still apply, and there's an interest penalty of 0.5% a month. So next slide, please. Now, speaking of tax penalties, your clients in the individual market should be aware that the tax penalty for non-compliance, that is to say the tax penalty for not having health insurance, is going to go up, and it's going to go up a lot. Whereas in 2014, the penalty was $95 or 1% of income, whichever is higher. Those figures go up in 2015 to $325, and then in 2016 it goes up to $695. And many
Steve,
people
does the 1% still apply?
Yes, and actually that goes up to 2% each year, so whichever is greater.
So in 2015, it's $325 or 2%.
Whichever is greater. Thank you for the clarification. Yeah, thank you. So this is, it's good you mentioned that, Dennis, because a lot of people have absolutely no idea that these fines go up. In fact, the Kaiser Foundation did a survey, and they found out that 72% of the people that they surveyed have absolutely no idea that that these penalties increase. And so I mention this because it's better that people find this information out from their agents and brokers rather than get a not so friendly reminder from the IRS come tax time. So now, if you want to get out of the mandate and all the tax penalties, you can claim an exemption, from the IRS. And the IRS has about 30 different categories of exemptions, ranging from financial hardship to religious exemptions. I don't claim to understand them all, but they do have a form for it, and that's now Form 8965. If you want to try to claim an exemption, but unless you can claim one and you don't have health insurance, you are going to have to pay the fine. And in fact, the Treasury Department is forecasting this year that as few as 3 million people, as many as 6 million people are going to pay the fine. And again, the fines go up. So you may want to direct some of your clients to a site called healthcare.gov/taxes. That kind of has a lot of answers to some frequently asked questions on the Affordable Care Act and what the various tax penalties are. So that might be a very useful site where you want to direct your clients to. So next slide, please. Now, I also want to talk about out-of-pocket cost limits. I think, as of 2014, the Affordable Care Act placed limits on out-of-pocket costs for deductibles, co-pays, and co-insurance. Those numbers are going up this year. In fact, last year it was $6,350 for individuals and $12,700 per family. But in 2015, those numbers go up. It goes up to $6,600 per individual and $13,200 per family. So you may want to mention that to your clients as well. Next slide, please. Now, I've obviously talked about what's coming in 2015, but I do want to mention to you what's coming down the road in 2016 and 2017. And so I want to go back to the employer mandate for a second, because starting in 2016, employers will have to file forms with the IRS to show that they're complying with the minimum essential benefits coverage requirements. And in fact, those are going to be done through some new tax forms. Those will be forms 1095B and 1095C, and again, those forms will just affect your clients in the group market, and those forms are going to be due by January 31st of 2016. Now, in 2017, some changes here too. some large employers will now be permitted in the shop exchanges. Really, until now, the shop exchanges have just been limited to small business, but again, come 2017, that opens up to large business as well. So, next slide. And let me also talk about some taxes. As you know, I think as everybody knows, the Affordable Care Act now imposes a whole series of taxes to fund the law, and I think one of the most controversial is the Cadillac tax, and this is effective in 2018. And this is a 40% excise tax on health plans where the aggregate benefit value exceeds $27,500 per family, or $10,000, $200 for individuals. And though this is not effective until 2018, this is already having an effect on the group market. In fact, employers are not waiting to address this issue. There's an interesting article from Bloomberg News back in January where Bloomberg noted that employers ranging from George Washington University to J.P. Morgan are looking to scale back their benefits in anticipation of this tax coming up here in 2018. But I'm actually going to come back to this tax too in my next section, which is, next slide please, which is what is Congress doing? And so, well now as a result of the last election, Congress has changed. And there are now Republican majorities in both chambers. In fact, Republicans now control the Senate with 54 seats, and they control the House with 247 seats, and that's actually the largest House Republican majority since the 1930s. But now that Congress has changed a bit more, there's certainly a political environment that we can say is a bit more receptive, if you will, to amending certain parts of the Affordable Care Act. The next slide. Now, surely there will be more votes to repeal the Affordable Care Act. In fact, there's already been some votes to actually do that. But even if by some chance that actually did pass, it'll surely be vetoed. Excuse me. And as I just mentioned, Republicans, while they have majorities in both chambers, they have a well short of the number of votes they would need to override a presidential veto.
Steve, political question.
Yeah, sure.
If the 2016 election would see a Republican come into office as president, is there any speculation that the Affordable Care Act could be completely repealed?
That is possible. I don't know at this point if I would say completely repealed, because there are some parts of the law that I think are still very popular. What I think I don't think the entire thing could go. I mean, for example, people are very supportive of the pre-existing condition clause. People seem to be very supportive of the other clause to allow your kids to stay on your parents' plan until you're age 26. And
no lifetime maximum.
No lifetime maximums and all these things. So I'm not sure if it could be entirely repealed. In fact, a lot of Republicans they're now starting to kind of coalesce around a plan to replace it, not necessarily repeal it outright. Okay. And of course, I'm going to talk about that in a bit too. And a lot of that actually may hinge on what the Supreme Court does, which I'm going to really get into that in a bit. And the decision there could reopen the Affordable Care Act and really put a lot of stuff into play again. So, but I'm going to get to all that too, definitely. So it's a great question, Dan. Appreciate that. And actually, to I think Dan's point, which is right on here, the Republican leadership has basically said that as long as Barack Obama is in the White House, you are not going to repeal the Affordable Care Act. And I think they've now come to that realization. However, having said that, they do want to target certain pieces of it, which may be able to pass. Some maybe not so much. But next slide, please. And in fact, one of the pieces that they've targeted, and this was earlier in the year, is a restoration of the 40-hour work week. And I think, as many of you watching have probably advised your clients in the group market, the Affordable Care Act, as I mentioned, altered the definition of full-time work to be 30 hours a week rather than 40 hours. And this has resulted in employers, cutting back on employee hours, and also cutting back on employees as well to get out of the mandate. And it was in the first week of the year that the House passed a bill to restore that definition of full-time work from 30 hours back to 40. This might be able to pass the Senate as well. There's a similar bill that's being developed in the Senate and sponsored by Senator Collins, who is a senator from Maine, and I'd characterize her as kind of being a moderate Republican, and of course sponsored by Senator Joe Donnelly from Indiana, who I'd characterize as being a moderate to conservative Democrat. So I'm not sure if where this is going to go yet, but I think there's definitely some support for this in the Senate as well. So. NAIFA backs this proposal. We think that proposal would undo some of the disruption to the workforce, especially as many people have seen their hours cut back and their wages cut back, and that of course means less money for saving for the important things in life, such as saving for your future and planning for retirement. And we've long argued that the employer-based system should be built upon, not proposals that actually would take us in the opposite direction. But I'll get into NAIFA advocacy a bit in the next section. There's also bills to repeal both the individual and the employer mandate. These are sponsored by Senator Alexander from Tennessee and Senator Hatch from Utah. And both these have, I think, a majority in both chambers, but again, I don't think they will certainly become law until 2017, maybe at the earliest. But I think both these bills were introduced in response to what the Supreme Court might do, which again, as I mentioned, could completely reopen the Affordable Care Act, and that decision, depending on how it goes, could put those two bills into play, which otherwise might not to be the case. So, and there are also bills to repeal various Affordable Care Act taxes. I just talked about the Cadillac tax in the last section, but coming back to it, I think there will be a move to repeal this as well. And the interest in doing so won't just be from Republicans. I think it'll definitely be from some Democrats too, as Democrats are certainly hearing from your organized labor associations, which are still a very important key constituency within the Democratic Party, and they have made it quite clear to Democrats that they adamantly oppose this tax, and that's really because one of the key benefits of joining a union is getting a very, very generous health plan, and this tax will certainly hit them the most. In fact, the AFL-CIO earlier, I think it was last year, had sent a letter to President Obama and the Democratic leadership in the House expressing their opposition to this tax, and in that letter, they said, and I think the exact quote was, "We voted for you, we have a problem, and you need to fix it." And I've never seen a trade association be quite that direct in their language. There are times when I'd like to be that direct, but obviously I can't. So, so they can kind of get away with it. So, so I anticipate that this will be quite an issue over the next year or so. And it's funny, sometimes politics can make for strange alliances, and this is one issue where certainly organized labor and a lot of Republicans may see eye to eye. So this might be quite an issue over the next couple of years. I do want to mention the medical device tax for a second. It doesn't affect our business and what we do, but I do mention it because there is bipartisan opposition to repealing this tax. And I mention that especially because sometimes when there's a bipartisan bill that's moving through, you never know what provision might get attached to it on its way to passage. So definitely keep an eye on that issue as well. There's also a small business tax credit that the ACA created. Which was designed to help small business provide insurance to their employees, and I found out just on the way up here really that there's a bill that's been introduced by Senator Coons, of course, from Delaware, and Senator Merkley from Oregon, and they have a bill that would dramatically expand this tax credit. It would apply up to 50 employees, and they would make it apply up to where the average wage is up to 330% of federal poverty level, or $80,000 a year. I think this issue is going to be discussed by the NAIFA Board of Trustees, and I think it'll be something that NAIFA will support. Historically, NAIFA has backed tax credits to buy health insurance, so I think this will probably be something that we would support. The political prospects of the bill I haven't yet ascertained, but we'll probably know more about that in the months ahead. Also on the way up, I did find out there is a bipartisan bill to eliminate the Affordable Care Act tax on health insurers. It's a bill dropped in the House, and it has sponsors in both parties, but again, haven't yet. It's maybe too soon to tell where that's going to go. So other measures have easily passed the House that are far less far-reaching and not quite as controversial as the other ones I mentioned. In fact, the House earlier this year passed a bill to exempt volunteer firefighters from the Affordable Care Act, and they also had a provision to exempt employees who are covered by TRICARE from being counted in the definition of a full-time equivalent employee. And in fact, both those bills passed with a room to spare. So I think those may pass the Senate as well. But again, those items are of course far less controversial than the other things.
Question on exemption.
Sure.
Why is it that members of Congress are exempted? That their health insurance is exempt from Affordable Care Act?
Well, actually, no. They have to be on the Affordable Care Act. In fact, that there was if you're a member of Congress and your staff, you're on the Affordable Care Act. They can't get out of it. So that was actually a very contentious issue, obviously during past passage of the bill. You could probably say maybe the optics of it would have looked horrible if they tried to exempt themselves.
Right.
So that's an issue there. Let me just try to get, actually, can you pause it just for 1 second, Dennis? Okay, and one other piece too that I want to talk about the Affordable Care Act are the Affordable Care Act co-ops. Now, these are not necessarily a target for elimination, though they are coming under some review and under scrutiny. These are known as the ACA, consumer operated and oriented plans, and these are the nonprofit entities that are owned by their policyholders, kind of like a mutual company, and set up under the Affordable Care Act. And they are subject to all the state licensing requirements and financial standards, and they're really intended to compete in the small group and individual markets. And I think agents should be especially paying attention to these co-ops because there's a chance that they might stop paying you sales commissions. Next slide, please. And here's what is very, very troubling is that according to AM Best, as reported by CNBC, 22 of the 23 co-ops collectively lost $244 million in the third quarter of 2014, and they've lost about $2 billion total. In fact, all of them so far seem to have, all except for one, seem to have debt and expenses that are at least 100% of the revenue that they're taking in. And the reasons for this are really threefold. There was a cut in federal loans to the Affordable Care Act co-ops, and these co-ops are eligible for federal loans to help finance their startup costs. And the ACA authorized about $6 billion in the loan pool, but in a budget agreement between Congress and the President at the end of 2012, that amount of money got cut to $3.8 billion. So that's still a lot of money, but still the pool of loans for them has been cut. They've also appear to be pricing their policies at a particularly low level, which makes one wonder if pricing policies so low can help them generate the amount of revenue that they need to pay claims. And speaking of claims, they all appear to have a very, very high level of claims, which tells me that the risk pool may be weighted in favor of a lot of older and unhealthier and sicker customers. So all these factors have come together to create a lot of financial trouble for these co-ops. And so far, the first and only one to go bankrupt was the one in Iowa, which was also operating in Nebraska as well. And it was late last year. In fact, maybe my next slide here. In fact, it was late last year that the regulators in Iowa discovered that the co-op was heading towards, insolvency. And at the end of 2014, an Iowa District Court placed the Iowa co-op in rehabilitation to be under the control of the Iowa Insurance Department, which is now basically taking the company into its bankruptcy phase. I think what's most troubling, and this is something that I really want to emphasize, is that in the rehabilitation phase, the Iowa Insurance Department made a controversial decision in order to save money to try to save this co-op to suspend commission payments to agents and other classes of various professionals as well. Now, NAIFA, Nebraska, where I mentioned the co-op was operating, they sent a letter to the governors of Nebraska and Iowa, and also lobbied the Iowa Insurance Department to get the department to reconsider this adverse decision. And the Iowa Department responded back to NAIFA and noted that because the co-op was in such dire shape, they really had no choice but to take some of these unpopular measures. They did mention, however, that because the guarantee associations can absorb most of all the claims to policyholders, and that the co-op is eligible for some reinsurance money under the Affordable Care Act, that there will be some money coming in, so agents will be able to. They may be able to recover some of the commissions they're owed, but I think it's doubtful that they'll get back all the money that they're owed. This has gotten some attention in Congress as well. In fact, Senator Grassley sent a letter to Health and Human Services asking that HHS preserve any and all documents related to this Iowa co-op. And the losses are definitely continuing. In fact, the co-ops in Arizona and Massachusetts are especially troubled, and the one in Tennessee, per an order from the Tennessee Department of Insurance, is no longer accepting new enrollees. So I mention this to you because we want you to be aware and be on the lookout for any co-op that might be in trouble. And if it is in trouble, we do recommend that you try to meet with the appropriate insurance regulators to make the case for a continued payment of agent commissions. And even before then, please do all due diligence when evaluating whether a co-op is right for any one of your clients. So, next slide, please. So with all this activity on the Hill, I want to tell you what we're doing at the NAIFA. And so with the Affordable Care Act being revisited by Congress and the courts, which I'll get into a bit later, NAIFA can use this as an opportunity to advocate for some targeted revisions to the Affordable Care Act. And one of the biggest issues that we've had is with the medical loss ratio. And I think as everyone understands that as of January 2011, per the Affordable Care Act, health plans in the individual market have to spend at least 80% of their premiums on claims and only 20% on administrative costs, and those figures go up to 85% and 15% respectively for the group plans. And this has been especially troubling to us because agent commissions have been included in the administrative costs. And so to meet the medical loss ratio, companies have cut back on some agent commissions, in some cases up to 50%. We did a survey last year of our agents, and really trying to find out how agents have adapted to working in this market in a post-Affordable Care Act world. And we found that 80% of the members that we surveyed and reported that they had seen a decreased commissions due to the medical loss ratio. And of course, with less money coming in, agents can't provide the same level of a service. And I've talked to some agents who, as a result, have had to cut back on HR assistance to some of their group clients. They've cut back on claims assistance. And in fact, in some cases, I've talked to agents that have actually had to lay off some staff as a result of it. So I think it's clear that some people have lost their jobs as a result of it. And our view is clear that agent commissions should be removed from the MLR. It's clear that insurance premiums have not been lowered as a result of this. In fact, they've only increased, actually. And there's already a bill in the Senate from Senator Cassidy from Louisiana. I think there's one in the House as well that would have a bill to remove agent commissions from medical loss ratio. It's been introduced in previous years as well. It's had bipartisan support, so this is definitely going to be an issue that we'll be working on this year. Another issue is the net income investment tax. This is also known as the 3.8% tax on annuities. And this tax specifically applies to individuals earning over $200,000 a year and couples earning over $250,000 a year. And taxes income from annuity distributions, including income on investments, dividends, and capital gains. And this was effective as of January 2013. NAIFA strongly opposes this. We've long argued that the price of health reform should not come at the expense of people who have made the decisions to responsibly plan for their future and save for their retirement. We've again long argued that the right policy is tax incentives, not policies that certainly take you in the exact opposite direction. Another issue is flexible spending account caps. I think post-Affordable Care Act, you may have found that for your clients that have FSAs, those accounts are not quite as flexible as they once were. As of January 2013, the contributions to FSAs not subject to federal tax is $2,500. NAIFA opposes that cap. We think this would especially hit consumers that have high out-of-pocket costs, such as consumers that have chronic conditions. Maybe you have kids with special needs, and so we think those individuals especially will be hit hardest by this. So again, NAIFA opposes that cap. There's also the issue of grandfathered plans. I think everyone will remember starting in mid-2013, millions of policyholders got cancellation notices that the plans they had are no longer compliant with the Affordable Care Act. And in many cases, they all had to buy a new plan, and in cases, pay a lot more for it. And this, of course, applies to policies that were issued before March of 2010. Now, in response to this, the administration, as many may recall, quickly put up a new rule allowing state insurance departments to permit people to keep their non-ACA plans to 2016. NAIFA is supporting an extension of that rule that would allow individuals and group clients as well to keep their non-ACA plans well into the future. I think there is a bill I now understand that has been introduced that would address this issue, and it would essentially take the extension through 2018, but I think it's a little too certain to ascertain what the political prospects are on that. So, next slide, Kate, please. And another aspect of the Affordable Care Act important to NAIFA has been the compression of the age band rating. In fact, post-Affordable Care Act, the age band rating is now 3-to-1, which of course superseded most state bands of 5-to-1. And under this rule, insurers can't charge older and unhealthier persons more than 3 times what they would charge a younger and healthier person. And of course, that may sound appealing to some, but to generate the funds that you would need to pay the claims, this means that insurers would need to raise rates, and this is, we think, in part, resulted in some of that sticker shock that many people have seen in their health insurance policies. So to keep insurance affordable, among many things, we support returning to the 5-to-1 age rating ban. And I do want to mention Medicare Advantage cuts. I think your clients who are seniors should know that the Affordable Care Act imposed cuts to Medicare Advantage by $200 billion. Those cuts will go into effect starting in 2012, all the way through 2019. And this is especially troubling because the Congressional Budget Office has predicted that these cuts will result in 3 million fewer enrollees, and maybe up to 4.8 million seniors could actually lose their Medicare Advantage coverage. In fact, it was last week, or maybe about 2 weeks ago, Health and Human Services announced that they intend to accelerate some of those cuts, and there was a bipartisan coalition of senators, about 53 or 54, that sent a letter to the administration opposing these cuts. And I think, interestingly, the senators opposing it ranged from senators that were very, very liberal to senators that were very, very conservative. So this definitely crossed the political spectrum. And NAIFA has and will continue to support full funding for Medicare Advantage and opposing these cuts, and that's something that we'll advocate on the Hill as well. Another issue is CE credit for exchange training. Obviously, before agents can enroll clients in the federal exchanges, you have to complete the required exchange training annually, and NAIFA thinks that agents should get CE credit for doing this. And late last year, we did have some preliminary discussions with Health and Human Services on this, and they have expressed some interest in it. And this is something that I hope we can continue working on throughout the year. Again, we think agents should get credit for this training. Last issue I'm going to mention here is on the healthcare navigators, and another area of focus for NAIFA has been to regulate the navigators to keep them from engaging in functions that are exclusive to licensed insurance agents and brokers. Navigators are, of course, the exchange workers who can help individuals understand the exchange website and how to apply for coverage, but what they can't do is actually recommend a specific insurance policy or direct someone to a policy. Although, unfortunately, in the real world, that's actually happened. And in fact, last summer, I mentioned we did a survey of our members in the health insurance market, and one of the questions that I asked our members was, have you experienced any difficulties working with the healthcare navigators? And 59% said they didn't, but 41% said that they had. And some of the common problems reported by the agents were that the navigators were poorly trained, they weren't very responsive to their clients, they didn't appear to know the various differences between the plans. But I think worse than that was we did find out that navigators had actually recommended certain policies, which again, that violates the Affordable Care Act. They can't do that. They have to remain impartial and fair. So the NAIFA Board of Trustees approved NAIFA policy and advocacy on this issue. The board approved a policy statement that said navigators should be trained that they cannot sell, solicit, negotiate, or recommend insurance coverage or do anything that is exclusive to only licensed insurance agents and brokers. As staff, we did take that message to the NAIC and to Health and Human Services, and I think some of the results were fairly good. We got the NAIC to amend a number of their training documents for exchanges to clearly state that navigators have to be trained that they can't sell or solicit or negotiate policies or do things that are exclusive to only licensed agents. And in equally, I think, and also good news, Health and Human Services broadly distributed a notice from the Arkansas Department of Insurance, which holds navigators to any and all state insurance licensing requirements. Now, I think both these are good measures, but of course they don't mean anything unless they're actually enforced by the federal and the state regulators. I have not heard any concerns raised by agents and brokers on this issue for some time, so I take that to mean that these measures are working, but this is still an area of a concern. And again, because we want to make sure that navigators are not going outside their boundaries that are clearly outlined in both federal and the state law. And next slide, please. Okay, so what will the Supreme Court do? So this has obviously been quite a topic this week. I think as everyone has heard, the court will very soon decide a very crucial and a very controversial case called King versus Burwell. And this challenges whether the Affordable Care Act subsidies in the federal exchanges are constitutional. The case is directed at a 2012 IRS ruling, which was a very controversial and very far-reaching rule that said qualified residents in all states, whether you lived in a state that set up its own exchange or whether you were living in a state that was using one of the federal exchanges, according to the IRS, you would be eligible for an Affordable Care Act tax credit if you're under a certain income threshold. And this is very, very controversial because the text of the Affordable Care Act quite clearly says that the Affordable Care Act tax credits are only to go to residents who live in states that set up their own state health exchange. Next slide, please. Now, the plaintiffs in this case, which are about the attorney generals in about 24 states and a pair of Virginia residents, are arguing that the law limits that per the text of the law limits the ACA benefits only to state-based state health exchanges per the statutory text of the Affordable Care Act. And they argue that because their states did not set up a state health exchange and therefore that they are not eligible for the Affordable Care Act benefits, that they should be exempt. The IRS rule should be thrown out because it illegally applies subsidies in every single state. And again, they're looking at the literal text of the Affordable Care Act. Next slide, please. Now, the defendants in this case, which is, of course, the administration, is countering that despite the language of the law, they're arguing that the intent of the Affordable Care Act was to provide an ACA tax credit to all qualified residents, regardless of where you lived, whether you lived in a state that had its own exchange or whether you lived in a state that didn't set up its own state health exchange. They also go on to argue that historically the courts have given deference to the executive branch to issue laws and regulations to carry out the intent of the law wherever the law appears to be conflicting, vague, or ambiguous in any way. Now, the court took this case because there's been a divide in the circuit courts. The circuit courts have been split. Usually where the circuit courts are aligned, then the Supreme Court doesn't take the case because there's no differences and there's no controversy. But there's been a divide in the circuit courts, and some of the courts have taken the side of the plaintiffs, and some of the courts have taken the side of the administration on this issue. And I think another way to really frame the issue before the court is the court really has to decide is the IRS rule I mentioned, is that simply the administration carrying out the intent of the law, or is that the administration rewriting the law, which again they can't do and is only the job of the legislative branch. Now, similar to 2012, it's believed that John Roberts will be the swing vote, although based on some of the oral arguments that the Supreme Court heard on this issue yesterday, Justice Kennedy may also be a swing vote as well. I think it's clear that certainly the three other the conservative justices will take what I'll kind of characterize as more of a textualist approach, in which case they'll say the plain meaning of the law says what it says, it means what it means, and that the executive branch just can't simply issue a new rule to rewrite the law because it's because they don't like what it says, or because it's not convenient. I think taking the other side will certainly be the four liberal justices. I think they will definitely argue that you can't just look at one section of the statute, you have to look at the entire law itself, and I think they'll definitely make the case that the intent of the law was to provide health insurance no matter where you lived, and I think they'll very much vote to uphold the administration's broad interpretation of the Affordable Care Act. And again, Chief Justice John Roberts and Justice Kennedy are the likely swing votes here, and they will decide. And it's very hard to tell where they're going to land because over their careers and the time on the bench, there are times when they've taken more that a textualist approach that I mentioned, and then there are times when they've been a bit more deferential to the executive branch. So it's very hard to tell where they're going to end up. I think a ruling in favor of the administration will of course just mean the status quo. Nothing will change there. But a ruling in favor of the plaintiffs, which is in other words a ruling against the Affordable Care Act, will mean that the ACA subsidies will be invalidated in the federal exchange states. In fact, there are 36 states where the federal exchanges are operational. And this could mean higher rates for millions of people who are getting health insurance through one of the federal exchanges. In fact, some of the studies have been all over the map, but there was a study by UBS Bank which forecasted that up to 9 million people could no longer be eligible for an Affordable Care Act tax credit, and they could see an increase in their health insurance rates as little as 35%, as much as 72%. So this could definitely have quite an effect if there's a ruling against the Affordable Care Act. If that is the outcome, Congress would have to move to immediately address the issue, which would, of course, reopen the law. We understand that the Republicans are preparing an alternative bill that, among many other things, would eliminate the Affordable Care Act mandates. It would reverse the age rating ban, which I talked about earlier. It would also expand the use of health savings accounts, FSAs and MSAs and so forth, and we think would leave in place some of the tax credits, or may grant an extension of those tax credits. Is too soon to tell, but I think that will be the framework that Republicans will use, again, if there is an adverse ruling against the Affordable Care Act. Now, apparently, there is no backup plan at the White House. Per the testimony of the Secretary of Treasury and the Secretary of Health and Human Services, they have no backup plan. It's almost, I guess, they're kind of at a point where they're essentially betting all in that the courts are going to see it their way. So, but we'll find out soon. I do want to emphasize that a ruling here against the Affordable Care Act does not overturn the law. And I remember when the court upheld the law in the summer of 2012, that was a totally different question before the court. The question then was, is the individual mandate constitutional? And of course the court said it was, because it's considered to be a tax. And under Article 1 of the Constitution, Congress has the power to raise and levy taxes, and that's the logic that the court used to uphold the law. So again, a ruling against the Affordable Care Act will still leave in place many pieces of the law, especially the subsidies through the state exchanges, the mandates and penalties and fees, the Medicaid expansion, pre-existing condition clause, being able to stay on your parents' plan to your 26. So all that stuff will still stay in place. But we're not going to know until the summer. The courts heard arguments yesterday, but we probably won't know until June. In fact, it probably won't be until late June until the court issues their ruling. So there's still some time before we actually decide where this ends up. So, and if you hit the next slide, please. Well, what else should agents and brokers know for 2015 and beyond? I do want to talk about the growth of private exchanges. And this is another issue that's popped up as well here over the past year. And I think under these arrangements, which are kind of similar to the multi-employer welfare arrangements, where multiple employers can band together and kind of set up an operation where company employees can select a plan from a list of options, and the employers will contribute a certain amount. This market is expected to grow rather fast. These types of exchanges tend to be pretty popular with more larger employers. I understand Target, Walgreens are two fairly large employers that have adopted this approach. Darden Restaurant is another one. I think a conglomerate that owns I think Olive Garden, Red Lobster, maybe a few other chains. There's a study from the Kaiser Foundation which is estimating that there are approximately 2.5 million people already enrolled in these private exchanges. In fact, that same study is predicting that over the next 5 years, between 20 and 33% of employers will enter into a private exchange, and that may cover as many as 39 million people by 2018. So I mentioned this because this is this looks like it could be a very, very fast evolving market. I've talked to some agents and advisors and just asked them how they're dealing with this issue, and it seems to me that I've heard from a lot of agents that they've kind of shifted to more of a consulting type of approach when dealing with these employers, and that consulting has been in helping maybe those employers choose some plans, and even deciding if a private exchange is the right path for them. But this is again a fast-growing market, and this is something new that we'll keep watching as well. I do want to talk about the Medicaid expansion. Now, the Affordable Care Act called for an expansion of Medicaid eligibility beginning in 2014, and the eligibility expanded to include everyone under the age of 65 with a household income of up to 138% of federal poverty level, which works out to be about $32,000 a year. Now, of that newly eligible population, the federal government will cover 100% of the cost to the expansion states from 2014 to 2016, and then they'll cover 90% of the costs thereafter. And hit the next slide, please. Now, per a Supreme Court ruling in 2012, this piece is not mandatory for the states, but 28 states chose to accept the Medicaid expansion and take federal funds. What you're seeing in the slide here is a chart from National Journal that explains this in a lot more detail. In fact, it shows which states have accepted the expansion, which states are still trying to decide, and which states have, at least until now, decided not to do it. And when I got this slide, I actually tried to kind of expand this a bit, but when I did, the text got a little bit blurry, but I hope that's kind of helpful to you. And I should mention, too, that if anyone watching this wants me to send you copies of these slides, please feel free to email me, and I can pick off some of those slides and send them your way. NAIFA has not taken a position on the Medicaid expansion, although we have generally supported the efforts of some states to develop alternatives to Medicaid, such as what's been happening, I think, in Arkansas, where the state has used expansion dollars to help people fund a private plan, almost like fund a premium support system, where enrollees could use Medicaid dollars to purchase a private plan, under the theory that over the long run this would help reduce overall Medicaid costs to the state. Next slide, please. Well, despite the many challenges and difficulties that in such a fast-changing and unstable environment the agents and brokers have had, the agent advisor community, I think, has been very, very successful in enrolling clients through the state and federal health exchanges. In fact, at the state level, we know agents account for almost 40% of the enrollment in the California exchange and almost 44% of the enrollment in the exchange in Kentucky. In fact, regulators in other states have definitely taken notice of this. In fact, the exchanges in Connecticut, Washington, D.C., Illinois, New York, and Rhode Island are all making efforts to reach out to agents and brokers. I think the regulators have clearly figured out that agents are far more productive, successful, and efficient in enrolling clients through the exchanges than are the healthcare navigators. And most state exchanges apparently now have a broker referral program in place that can allow consumers to connect with a local agent to give them some guidance and some advice. In fact, at NAIFA National, we've taken those figures to the NAIC, and we testified at the NAIC urging regulators in state exchanges to make greater use of these programs, again, to connect consumers with a local agent, and the agent can help them decide whether signing up through the exchange is the right plan, or maybe going on the private market is the right plan. So we think these programs are good, and we think the state exchanges need to make greater use of these. So next slide, please. Now, in all this, there is such a crucial role for agents and brokers and advisors, and without you all doing what you do, people have to try to figure all this stuff out by themselves, and it's now more complicated and more complex than ever to buy insurance, especially with all the mandates and penalties and taxes and fees, and it's better that people connect with an agent and broker, learn what their options are, so they keep themselves out of trouble with the IRS, as I mentioned, but also more importantly help you find a plan that's right for you. So. Well, I do want to end with just a few final thoughts. I hope you found this information to be helpful and worth your time to watch this, and I hope you found it helpful as you advised your clients, and I hope it's helpful as you work in your own business as well. So, next slide, please. Well, I do want to end in a little bit of a shameless self-promotion for NAIFA. If you're able to attend, I hope you will consider coming out to the NAIFA Congressional Conference in the middle of May. And if you haven't been, this is a really fun event where you get to join your NAIFA colleagues and staff, and we go around on the Hill to meet your congressmen and senators and lobby on issues that are important to not just your business, but also the business of your clients. And usually we have members from every single state. We usually get usually between 500 700 members come out, so it's a pretty well attended event. We always get a lot of great feedback from members. So if you haven't been, it's something that I hope you'll consider. And again, it's at the end of May, and feel free to give me a call. I'll put my contact information up before we leave, and I hope you will consider coming out to this. So, last slide, please. Well, last but not least, I just want to thank the entire team here at NAIFA Delaware for inviting me, and I especially want to thank Kate, Dan, and Debbie, and I've certainly enjoyed the opportunity to be here, and like I said, I hope everyone watching this found it helpful to you and your clients, and if you have any questions, you can see my contact information there, so feel free to send me an email or give me a call, and I'm happy to talk to you about this issue or any other issue as well, and hope you found this information to be very, very helpful to you. So thank you all.
All right, NAIFA Delaware, thanks. Stand by for our next speaker. I want to thank Steve for coming up from Falls Church and presenting us with ACA. His contact information will be there. He is a phone call or email away if he can be of support. So thank you, Steve, for coming up.
Thank you. Absolutely. Glad to do it.
Stand by, NAIFA Delaware. Okay, NAIFA, thank you very much. We appreciate the flexibility and patience as we got through last Thursday's winter storm. Information will be in the email for those that registered on how to earn your CEs. The PowerPoints are going to be attached to that email, and then you'll have to let Kate know your license number, etc., so she can apply for your CEs. Again, a last shout out: Mike Walker from Mid-Atlantic Benefits Group, Nick Moriello from Health Insurance Associates, and the Weiner Benefits Group were sponsors of this meeting, and we really appreciate it. We could not do stuff like this without the help of our sponsors. So thanks, NAIFA Delaware, for being a member. We're always a phone call away. Bye-bye.